Superficially, and actually substantively, there are quite a few similarities between the large number of China-based companies that have listed in the United States and those that are listed on Hong Kong in recent years for a number of well-documented reasons, largely to do with some reputational issues that have affected some Chinese companies that have been listed on the US. There's been a large number of take-private transactions of those companies. They very often involve the founding shareholder or controlling shareholder of the company taking the company private, delisting it from the US exchange on which it's been listed, normally in conjunction with private equity financing. As I say, there are a number of similarities in those kinds of transactions, and privatizations in Hong Kong. The businesses are both based in China. They're publicly listed. Very often there's a controlling shareholder, normally the founder or family members who want to take the business private. The big difference has been that I've identified, coming at it from the perspective of the Hong Kong angle, is that in terms of the legal structure by which these transactions have been implemented, almost all of the US take-privates have been implemented by way of a merger under the local law of the jurisdiction of incorporation of the holding company. Very often that's the Cayman Islands. And there are a number of attractions of using a merger under Cayman Islands law in terms of the simplicity and speed and the ease of getting the requisite shareholder vote through. In Hong Kong, these type of transactions, privatizations, are typically implemented by ways of schemes of arrangement or offers. And anecdotal evidence, as well as the results of our survey and the research we've done, indicates that almost all, in fact, pretty much all of the privatizations of Cayman incorporated Hong Kong listed companies have been implemented by way of schemes of arrangement or offers, and there has not been a merger involving such a company in Hong Kong, of which we're aware. Complicated, it's a highly regulated area. You do need to have a good understanding of a variety of rules and regulations and the laws that will apply to the transaction. It is a significant undertaking. So, in all seriousness, you do need sophisticated and experienced advisors, particularly if the transaction is going to be of a significant size. You do need people who can pull together the knowledge of local laws, for example, in the Cayman Islands, Bermuda, wherever the target company is incorporated. Also be familiar with the requirements of the Hong Kong Takeovers Code, and you've got to bear in mind the need to interact very closely with the SFC, which implements the Takeovers Code in the Hong Kong Stock Exchange. Aside from that, bearing in mind the particular requirements of the Hong Kong Takeovers Code when it comes to a squeeze out in the case of takeover offers, or the voting requirements in the case of schemes of arrangement and probably mergers, you've got to bear in mind that the code is there to protect minority shareholders, and that minority shareholders, the deal overall has to be attractive enough to the minority to get them to vote it through. And there is precedent in Hong Kong for deals, even though they've gotten support from controlling shareholders with a significant stake in the company, because of the particular rules of the Takeovers Code, the deals didn't go through because they were not judged by the minority shareholders to be attractive enough. So, you do have to bear in mind that the need to appeal to the minority and to get sufficient votes on board and sufficient support on board in order to implement the transaction successfully.